And without further ado, I'd like to introduce Professor David Trubek, who is chairing our first panel of the day entitled The University of Wisconsin Law School in the Global South, 60 Years of Engagement and Innovative Scholarship. Thank you. We'll have you unmute, Professor Trubek.
Yeah.
Thank you.
Thanks a lot, Connor and Abby. Thanks for putting this together. I think that all of you is doing a great service to the university, to the law school, and to us, and we really appreciate that. I have the honor of being the chair and introducing this panel, and so I'm going to start by putting up some slides. This is the UW Law School and the Global South, 60 years of engagement. This is, we here deal with a somewhat unusual phenomenon of a law school in the middle of the country that has an incredibly deep bench of people who work on the countries of the Global South, broadly defined to include the former Soviet Union. And the thing that's important to understand is that this is not something new. This goes back 60 years. The 60 years, the University of Wisconsin Law School has been the premier law school to deal with, in the United States, to deal with this part of the world. Okay. Now, we have a special commitment to the Global South. We study global issues, democracy, constitutionalism, the role of law in economic development, the legal profession, climate change, human rights, women, whatever, criminal issues, but we do it through a regional focus to a great degree. We do it global, but we also especially look regionally at particular countries, particular parts of the world. We look at Russia, we look at Latin America, we look at Africa, we look at East Asia, we look at South Asia. Now, why? Why do you think, how did this happen? I think you have to go way back into history. Even before I arrived in a law school in '73, but I was quite connected to the law school up to that point because I was involved in the same sorts of issues that Wisconsin was already specializing in. That was a university-wide commitment to what was then called the Third World, particularly development assistance and area studies, Latin American studies, African studies, and so on. These were 1960s projects, both of them, and Wisconsin jumped into this world more than almost all other universities, or at least as much as any university in the United States. At the law school level, this came in large part because of the engagement of law school faculty in development projects through the Land Tenure Center and otherwise, and through participation in rule of law export projects, particularly teaching in places like Africa, South America, India, and so on. But an added dimension was that Willard Hurst, who was the premier scholar of the time, had emphasized the importance of studying law's role in American economic development, which legitimated this as an intellectual subject in a way that would otherwise perhaps not have happened. And therefore, it was picked up by the faculty as a major theme before almost anybody else in the country did that. Now, today, this commitment is built on 5 pillars. There's the Institute for Legal Studies, which is a general institute that covers all sorts of topics. The Global Legal Studies Center, which focuses on more global issues. East Asian Legal Studies Center, the South Asian Legal Studies Workshop, and the UW Institute for Regional and International Studies, which is campus-wide, and which I believe all of the panelists are active participants in the regional and international programs that operate at the campus level. So this is a very rich kind of institutional environment. So without further ado, I'm going to introduce the panelists. They are a unique team of awesome people. And I want to make clear that I'm not going to take the time to go through their extensive bibliographies, CVs, all the things they've done all over the world. all the awards they've won, it's just, I mean, it's awesome. But seriously, we just don't have time. However, their bios are on the website of this event, at the Symposium website, and since they're all members of the UW faculty, also on the campus website. So without further ado, here they are in this order: Sumudu Atapattu, who's a senior lecturer and director of the research centers; Kathryn Hendley, Ross Bascom Professor of Law and Political Science; Alex Huneeus, Director of Global Legal Studies and Professor; Heinz Klug, Ebu Bascom Professor of Law; John Ohnesorge, Director of East Asian Legal Studies; and George Young Bascom Professor of Law and Mitra Sharafi, Professor of Law and Coordinator of the South Asian Workshop. And that order, everybody has 10 minutes, and here we go. On Wisconsin.
Okay, thank you so much, Dave, for that introduction. It's a bit of a pressure on us. You are so awesome. So I'm going to time myself, and I would also like to thank Abby and Connor for putting this event together, and it was a pleasure working with you guys. I'm going to talk about climate justice, but before I do that, I want to talk a little bit about my own work. The book chapter that I'm presenting today is part of an edited volume with Cambridge, and hopefully that will come before the end of the year. The book is called Cambridge Handbook of Environmental Justice and Sustainable Development, and it tries to look at the link between environmental justice and sustainable development, especially the social pillar of sustainable development, which hasn't really received much attention in scholarship. So we do this through the first part of the book looks at different frameworks and theoretical frameworks. And the second part really is the crux of the book, which looks at various case studies from around the world. And my book chapter, which is a co-authored piece, is part of that second section. Specifically about my own work, I look at the link between human rights and environmental issues, and how a human rights framework can be useful for victims of environmental degradation and pollution. And specifically, I look at climate change and human rights, climate displacement, small island states, and how a human rights framework can be useful and necessary in relation to both mitigation and adaptation measures that states have to take in relation to climate change. I feel a bit of an outlier on this panel because I don't specifically look at the global south, because my work is more global in dimension, but this particular chapter looks at Maldives, climate change in relation to the Maldives, and linking my own work to Wisconsin. One of the scholars that I have greatly admired is Professor Richard Bilder, who is a very well-known international lawyer, and even before I came to Wisconsin, I knew of his work. Looking at the paper itself, it's called Climate Justice, Sustainable Development and Small Island States, a case study of the Maldives. As we know, the small island states are particularly vulnerable to consequences of climate change, with sea level rise associated with climate change, as well as severe weather events that are already taking place in many parts of the world. And there are lots of legal issues that arise as a result of, particularly with regard to small island states, because territory is one of the necessary criteria of statehood. So if territory disappears, then what happens to these small islands? We are talking about close to 50 sovereign nations, and legal scholars are talking about what happens to these entities if territory disappears. Some scholars argue that people will start moving long before the territory disappears, and it's already happening actually. So there are lots of legal questions relating to statehood, nationality, self-determination of people, and the humanitarian question about what happens to these people if and when they have to move, where will they go? In fact, cases are already coming up before human rights bodies with regard to issues of refugees. And recently the Human Rights Committee recognized that climate change could trigger the application of the non-refoulement principle, because climate change poses a serious risk to right to life if people are sent back to their home countries. So looking at the Maldives itself, again, it's a small island state in the Indian Ocean, and it's barely above the sea level. So the Intergovernmental Panel on Climate Change recognized the unique vulnerability of small island states to climate change, and the disproportionate impact on these states, because the industrialized countries are contributed much more, as we know, to the problem, but the small island states and vulnerable communities are disproportionately affected by the consequences of climate change, and the Maldives is one of them. So if you look at its geography, it's an archipelago consisting of close to 2,000 islands, actually 1,200 islands, and most of which are less than 2 meters above sea level. And if you look at the predictions, sea levels already risen, and the predictions, the scientific predictions, are that the sea levels will rise close to 1 meter by the end of this century. So you can just imagine what would happen to the Maldives by the end of the century. But long before that, the islands are already being affected by other environmental issues as well as politics. So tourism is the driving force of the Maldivian economy, and the politicians are very worried about the impact on the economy as well. Although climate change dominates the conversation, day-to-day environmental issues such as pollution, sewage are of immediate concern in the Maldives. And some people say that the focus on climate change takes away attention from these day-to-day issues. And poverty is another issue. Political instability have exacerbated these social vulnerabilities. Attention is focused mainly on the capital Male. The other islands have not been really the others on the islands have not really been paid attention to. Politically, there have been lots of flip-flopping in the Maldives. Let me keep an eye on the time, 2 minutes. The former president, who was called the island president, and there's actually a documentary on him, paid attention. He championed climate change at the global level. But after he had to resign, the new president came and said, you know, climate change is one of the problems. We need to pay more attention to development. So he actually negotiated with King of Saudi Arabia to sell an entire atoll consisting of 19 coral islands for $10 billion US. So, so how did that happen, right? Did the people consulted? So there's a stark contrast between the approach taken by President Yamin to President Nasheed. And some of the people in the small islands are located without their consent. These poor fishermen don't want to move. So there are lots of political issues in addition to climate change. The country built an artificial island at a cost of $63 million US dollars to meet housing, industry, commercial development demands of the Mali region. So some people argue that this could be a solution to disappearing states. But of course, the question is who is going to pay the cost? The case study highlighted the tensions among, oops, that's my time, I'm almost done, about climate change, economic development, sustainable development, and environmental justice issues, and the role played by politics and politicians. The ordinary people are suffering the negative consequences of climate change. And what about their right to self-determination? And of course, the larger question of the humanitarian issue of where these people will go. So I'll stop there. Thank you so much.
So Dave, I should just go ahead and start? You're not gonna do anything? Okay, fine. All right, so I wanted to join the others in thanking Abby and Connor, as well as Dave, for organizing this panel. Those of us who've been here for a while got used to having Dave around all the time, and it's nice to have him back, if only virtually. I know that Dave and Louise had a big plan to come and be here with all of us and also with their granddaughter, but that has all been spoiled by the virus. But it's good to know that it's just, that at the end is just around the corner. So we learned that last night, right? Okay, so the question that I'm interested in my research focuses on Russia, and I'm looking at the large question of how do lawyers exist and what are their roles under authoritarianism. And I'm particularly interested in the question of how does society view lawyers and how do lawyers view themselves. That there's been a fair amount of work done on exploring different kinds of lawyers and what do they do, and what kinds of cases do they take and all that kind of stuff, but less on the question of how does society see them, and then how do they view their own role. And so that's what I hope I'm bringing to this particular project in this paper. So I'm looking at the beginning in the Soviet era, where the information is limited because, of course, the ability to do research was quite limited during that time. We have some really wonderful memoirs that are helpful, and even though they aren't really about my questions, they inevitably touch on my questions. And then these monographs about different types of lawyers. But the heart of my paper is really about the present day and about how lawyers are viewed in the post-Soviet era. And so there again, I can use secondary sources, but I'm also bringing in some data. And so I have a survey that I didn't do, but that a public policy group did in 2008, where they asked a representative sample, what kind of lawyers they thought were the most respected. And then I also include some of my work, which I did a survey with an N of about 2,200 of graduating law students in Russia in 2016. And then we did a series of follow-up interviews with those respondents. And so we're able to try to get at some of these issues. So just a little bit of background information. Russia is a late developer on many things, and the legal profession is just one of these, that you really couldn't speak of having a legal profession until you had these large reforms that dealt with the courts, with lots of different things in 1864. And if you think about, where we were in 1864 in terms of the development of our legal profession, you would realize that that's really quite late to be getting organized, but Russia was still in almost in a feudal system at that period. The other thing is that legal education, like the rest of Europe, is an undergraduate enterprise, and that like a lot of European countries, lawyers don't really think of themselves as lawyers per se. They think of themselves as a particular type of lawyer. And whether this balkanization was totally responsible for the blunting of political power, I think probably not entirely, because lawyers did have a fair amount of esteem during the Tsarist period before 1917. But then with Lenin coming in and the sort of disrespect for all professionals, including lawyers and judges, this really undermined any kind of political role they might have had. So here we see a kind of an overview of the different kinds of lawyers. And what I've done is, kind of put the different things that we would think that you need lawyers for in the first column, and then in the second column, what we had in the Soviet period, and then in the post-Soviet period. So we see that with the yellow, that's the only part of the profession that had any semblance of not working for the state, were the litigators and people who defended in the criminal setting. Now their freedom of movement was quite limited, but at least they were more private. And what you see on the other side, that the blue represents entirely new parts of the legal profession in the post-Soviet period, and the green represents the folks that existed in both eras, but now are private as before they were public. So there we go. So looking at the question of what did Soviets think about lawyers, I actually wanted to show you a clip from a Cold War era movie where they deal with this issue, and I thought it would be interesting for us to have something a little bit different here. So let me pull that up. See if I can do this real quick here. Let's see, where is it? Here it is. Okay, share screen. Oops, second. Okay, never works the way you plan it, does it? Okay, so here we go. And let me just pull it up to the moment where I want us to be looking at it.
Is in the interest of the stronger.
Professor Huneeus, you can't see a video screen.
Okay, all right. I think I'm just going to skip it then. Too many moving parts at the same time. We'll go back to the PowerPoint. So the point here is that, as I mentioned before, we have very limited information about our understanding of what lawyers were doing. Or yeah, I'm going to get it up, Dave. Don't worry.
Oh, okay. I'm sorry.
Okay. So I'm just continuing on with the chatting here. So here we go. Here we go. Okay, so we have limited information. We have some ability to gauge the prestige of various specialties based on gender that we have in the criminal justice sphere. We have mostly male-dominated professions, and then in the female-dominated professions, some of these are a little bit surprising. Judges, for example, but other people, defense lawyers, in-house lawyers, notaries, these were people who were mostly women. And the question of what you wanted to be, you didn't have complete freedom of movement there, because since it was a planned economy, the labor market was also planned. But we get a sense from the memoirs about which kinds of specialties were the most popular. Okay, so let's get to the heart of it here. The things that are interesting to us. So what changes when we move out of the Soviet Union into the post-Soviet Russia? The first thing is that we have a market, right? And the market gives rise to a new kind of demand for a lawyer. And so we see here that law firms begin to evolve. And here we see a story that's been told in many other parts of the world as well, where at first we see big Western law firms coming in, and eventually with mostly staffed by expats, and then eventually staffed almost now entirely by Russians. But we also see that with the privatization of industry, that in-house lawyers are also now private lawyers, and they have become more value added. That I think in the Soviet period and even in the 1990s, there was a sense that, what is the point of having a lawyer? And that has all changed or is beginning to change. I don't know. It certainly has changed in Moscow and St. Petersburg. The extent to which has changed in the rest of Russia is an open question, simply because nobody has done the research. The other thing we see is that because it is a labor market, you can move around from one thing to another. On the negative side, there was a very concerted effort on the part of, led by mostly by the American Bar Association, working with these defense lawyers, these advocati, to try to create the kind of monopoly that we have. And interestingly enough, it failed because the Constitutional Court wouldn't go along with it. They said that the Constitution gave everybody the right to pick whoever they wanted to represent them. And so if they didn't want to have an advocate, they didn't have to. And so, but they recognized that in a criminal case, you would need someone who actually knew what they were doing. So this is beginning to, we're seeing some cracks in that the procedural codes now say that you should have somebody with legal education, but that's relatively new. For many years, when I would sit in courtrooms and I would see someone who wasn't really very good at what they were doing, I would ask the judge, do they have a legal education? And the judge would say, I don't know, I can't ask them, right? I think my time is quickly running out here. So here's the 2008 survey. And what we see here is, what do Russians think? A little bit dated, these data are, but we see that the top two vote getters out of the people who don't have any opinion, which is the unsure, are prosecutors and defense lawyers. And we also see that investigators, who are the police type of people, they have a very low esteem, and so on. So this gives us a little bit of a sense of how ordinary Russians think about lawyers. I think that it's not a perfect question, because I'm not sure how many Russians actually understand the differences between all these different kinds of lawyers. Certainly they understand the difference between a prosecutor and a defense lawyer, but whether they understand the difference between, a notary and all these other kinds of lawyers is less clear. So in my 2016 survey, we asked, and here we're in the market, so people that are graduating from law school, just like our students, have the right to do whatever they want. And so you see here, we ask them, where are you planning to put your flag down? What kind of lawyer do you want to be? And I divided them up here between private sector and state sector. We see a story where there's a lot of interest in the private sector, but the thing that I think was surprising for me and for a lot of people about this, so here we are, almost 30 years into the post-Soviet world, and yet we see that if we did a total percentage here, that there are more people interested in staying in the state sector than going in the public sector, in the private sector rather, which was a little bit of a puzzle, and I think an interesting one. And I have a separate paper where I've looked at the difference in attitudes, and you can see a real fissure between attitudes on people who are interested in the private sector and the public sector in terms of democracy and other kinds of things like that. So that gives us a little bit of a snapshot there. And then we had a question where we could, these interviews where we could ask them in a little bit more detail about what did they think were the most prestigious specialties. And you really see two kinds of rationales coming through here. One is authority. Do you have the right to sort of tell people what to do? And so judges come across as being a very prestigious career option. But so too, defense lawyers were the second choice. And so they're looking at salary and work conditions. And so here we see the role of the market, the idea that salaries are now a very important thing. And this also comes out in yet another data source that I use in the paper, and that is public opinion polling of parents and grandparents about what would you like your kids to be. In the Soviet era, lawyers weren't even part of the story to the extent that we have any data like this. And now they tend to be relatively high. And we also see, the other thing I haven't mentioned is that there's been a huge increase in numbers of law schools and people going to law school, also with a lot of uncertainty about the the quality of those law schools. I think I'm almost out of time here, so let me just give you a few preliminary conclusions. I think that one of the things that's been undiscussed and unheralded in the discussion of the collapse of the Soviet Union is the fact that it really has opened the door to a complete rethinking of what we want lawyers to be. And I think this has mostly flourished in the private setting, right? That we see this whole world of lawyers who have taken up the, work for big companies, help big companies get onto various stock exchanges, all that kind of stuff. What hasn't happened is a flourishing of the idea that lawyers should be speaking truth to powers, that they should be defending people against the state. And we see that this accusatory bias, this tendency of the Russian criminal courts to convict everybody has not really decreased. And so lawyers are tentative about pushing themselves in, and the procedural rules limit their ability to do so. So with that, I think I've probably even gone over my time, and I apologize for that. But I will close with that. And thanks for your attention.
I believe I am next, David. Okay. So like the others, I want to really thank the Wisconsin. What's that?
You're next.
Okay. Everyone can hear me. So I want to thank the Wisconsin Law Review for their interest in our traditions and for this opportunity to share my current research. I want to thank Dave Trubek for herding us cats together, which can be difficult, and for this reminder of the importance of really getting together and thinking about where we sit together within the scholarly world. In my comments, I'm going to just focus on the rights of nature movement in the United States and the Global South for the first part, which is what my paper will be about for the journal. And then I'm going to use that article as a way to reflect on our tradition in the last few minutes of my talk, all, of course, in the space of now 9.5 minutes. And I'm going to set my timer here. So in February of last year, the residents of the town of Toledo, Ohio, adopted the Lake Erie Bill of Rights. And through this amendment to their city charter, they sought to transform one of North America's Great Lakes into a legal subject with a right to exist, flourish, and naturally evolve. They also granted Lake Erie standing to pursue its rights in the Court of Common Pleas. At that moment, Lake Erie briefly found itself in the company of this growing group of rights-bearing natural entities from the Global South. Over the past 15 years only, earth beings, ecosystems, and nature itself have been granted legal rights and have begun to litigate in court in countries as diverse as Colombia, Mexico, India, and New Zealand, and Uganda, just to name a few. Rivers feature prominently in this trend, but the list includes forest, mountains, lakes, glaciers, and even wild rice. At the international level, the UN General Assembly has taken notes of right of nature laws and called for a dialogue with earth jurisprudence. And at least one international court has declared that living organisms with which we share the planet are worthy of protection in and of themselves and not because of their use to humans. Scholars have taken up these events, and a great number of books and symposia and articles have been published in recent years. One aspect of this environmental movement that has been less explored is that by some tellings, it originated in the United States and continues to unfold stateside through the passage of town and city ordinances. Over 50 communities in 11 states and 5 Native American nations have passed laws that recognize the rights of ecosystems, natural communities, and particular entities here in the US. And 2 states have at least introduced legislation for rights of nature. In other words, the movement isn't only rooted in smaller developing countries, it's also rooted, albeit less sturdily, in the industrialized, carbon-producing, Paris-avoiding United States. My article is going to examine the movement to translate into rights law the idea that natural entities are ends in themselves by focusing on the United States and its relationship to the Global South movements. And this is not some teleological story of an underdog social movement that's slated to change the way we do things in the US. In Ohio, Lake Erie's claim to legal status was quickly quashed. The day after the Bill of Rights passed, a local farmer filed suit and the federal district court struck down the law just this year. The Ohio legislature, meanwhile, moved to preempt similar efforts and passed a law barring entities that are not human or human creations from having standing in court. And indeed, of the 54 ordinances that have been passed here in the US, none has survived a court challenge. Federal courts consistently have also denied standing to natural entities in our courts. Yet quixotically, the movement persists. And the story of the US movement and its relation to this global South movement is important, therefore, not because these rights are someday coming to a river near us. Rather, my argument will be threefold. I'm just going to check my time. First, it shows how a social movement focused on law can sustain itself without legal footing and without a court victory, in part through its connection to and reliance on legal movements that unfold in the global South. So it's this reverse flow dynamic. The United States movement uses global South movements and laws to ground itself rhetorically and for fundraising, and eventually to redefine its own objectives. Further, it shows the social movement's trajectory shows how legal idea or movement can conjoin two dramatically different constituencies across borders. In most other countries, the legal person of natural beings comes tied to an effort to bring an indigenous, non-Western view into the main Westernized legal system. The movement in the US began grounded not in this indigenous cosmopolitics, but rather in the pragmatic search for a legal tool with which to ban fracking in suburban communities in the mid-2000s. So it's in this way that a legal innovation in other places, typically identified with leftist governments or ethnically identified non-Western peoples, is in the United States, at least it started out identified with white middle-class suburban and rural communities, and not infrequently Republican ones. And finally, the article will show how the US movement has been reshaped by its interaction with global South right of nature movements. So it's moved from a not in my backyard NIMBY challenge to corporate personhood to a movement that seeks to reshape our understanding of our relationship to nature, drawing on indigenous philosophies and increasingly engaging with US native nations. So you could even say that in this reverse dynamic, foreign native nations have influenced the US movement to move towards indigenous peoples and cultures in the US. So that's a summary of where my article is headed. I now want to turn to make some connections with our tradition as I see it. So first of all, it's rooted in the socio-legal tradition. It draws on interviews and systematic qualitative data analysis and engages with law and social movements theory. So it's asking not about the law itself alone, but also about the groups that mobilize the law in order to advance a political claim and ideas. Also, it's rooted in the critical global South tradition or in conversation with it, because it reverses this tendency to examine how Northern ideas influence the global South, instead casting global South legal actors as authors of transnational ideas. And I want to dwell on this point because well, I believe the originality of the Wisconsin International Comparative Scholarship has been, of course, to focus on the global South. And while this began in the 1960s with this characteristic arrogance of Americans trying to reform Africans and Latin Americans, that stopped abruptly with the foundational article written by David Trubek and Mark Galanter, Scholars in Self-Estrangement, in 1974. Now, I happened to run into that article while working on a project by the World Bank to spend millions of dollars reforming the Argentine judicial system, which went nowhere because it blithely was reinventing the wheel anew without knowledge of the law and development tradition. But it was an article, and so I ran into it while I was doing that, and the article greatly influenced me. The more recent trajectory of global South scholarship from UW, or at least an important strand of it, isn't focused on reforming global South in our image, and rather I'd highlight three strands that run through it. And here I'm actually going to am I going to? Yes, I'm going to share an image that's an antidote to the image that David shared with you of the global map. Okay, you can see that? Yes, okay. So I want to point out three features that I see in our current scholarship. One, that it's deeply engaged with local actors and scholars. So it's less of a relation of us, them, but more level and focused on amplifying voices of the global South. Here, I think of Kathryn Hendley's deep ongoing engagement and grounded knowledge of Russia that's more akin almost to the relationship that an anthropologist has to their case study than your typical legal scholar or even political scientist. And I think of David's work on Brazil. He's brought new generations of Brazilian scholars into conversation with the US Legal Academy. So it's this conversation that's based on long-rooted relationships on a more level playing field. Second, viewing the global South not as a recipient of legal innovation, but as authors and inventors of important legal change and innovation. Here, of course, I think of Heinz Klug's work on South African constitutionalism. And even though Sumudu disavowed that she writes about the global South, I disagree. A lot of her writing is based, and some of her early writing on climate litigation and other environmental law innovations of South Asia also works in that tradition, and my own work on the inter-American human rights system. But finally, I do point to a theme of continuity. I believe that even if we've been cured from the reformist urge, I think we're still seduced by the idea that law can be used to create a more equitable, a more free, a better world. So, and me seduced by the myth of rights, or the ability of law to create significant counter-hegemonic change. And it's a very questionable premise, but I do think it continues to animate much of what we do. And as Boaventura Santos, who is in some ways still part of this tradition, might argue, there are moments when law bursts through its conventional confines and makes a difference. And I think a good part of our work is still in search of those moments. Okay, I think I'm back. Yes. So oh, perfect timing. So I'll stop there. Thank you.
So then Heinz Klug.
Yes, before that, we're going to do the CLE announcement briefly for the Wisconsin attorneys. So I'm going to share my screen now. The first password for CLE this morning is GO. That's G-O, and you can see it on the screen here. If you have any questions about CLE, you can email me and I'll include my information in the chat, but the first password is GO. Thank you. Professor Klug, go ahead.
Thank you very much. Great, so I'll try and be fairly brief. First of all, I'd like to thank Abigail Chase and Connor Clegg for giving us this opportunity, and David Trubek for pulling us all together, and my colleagues for being part of this. So I'm very interested that a journal is celebrating 100 years, looking at our intellectual history and tradition. And what I want to focus on particularly is explore the relationship between economics and governance in this particular part of our tradition. If we look at our law school, as David Trubek said right in the beginning, we have this long, at least 60-year history in an interest in the relationship between North America and the global South. At least law beyond the borders of the United States. If we look at this history, we see that it starts, as David will point out, with this engagement that many of our faculty had going abroad as teachers in law schools all over Africa, all over Latin America, or other experiences they had in the global South before they came back and started working as professors, or while they were young professors here at the law school. When I first joined the faculty in the mid-90s, many of my senior colleagues had spent time in different African universities all over Latin America and other places. And I think what slowly happens is the research arm starts to move in that direction as well. If people began initially as going out as teachers, they quickly learned that they had an interest in the places where they were teaching and began to do research. And that initially is focused to a large extent on the law and development, on the idea that if we get the law right, we'll get the economics right, and that would work together. And what you see in that initially, the development of that relationship, you see in a number of different ways. But what was most interesting to me is, I think that that initial idea, as David said a little earlier in his introduction, was legitimated by the fact that we already had at Wisconsin a long history that Willard Hurst represents of interest in the relationship between the economy and law. Going right back to John R. Commons, etc., within the Wisconsin tradition. And so the kind of Wisconsin idea going out into the world, at least to the state and then to the world through this, becomes very much part of what this faculty does for a long, long time. And it evolves in different ways. As Alex just said, it evolves in a way where David and Mark Galante together write this piece criticizing the law and development movement. But that doesn't mean law and development goes away. It evolves, it changes in different ways. And what's interesting is the question then is, well, what's the relationship between the economic development and law and the question of governance? And what's interesting, I went back and looked at a piece that Bill Whitford published in the 2007 issue of the Wisconsin Law Review, where he goes back and thinks about that period as well. And he talks about the fact that at least in East Africa, where he was teaching at the university in Tanzania and in Kenya, there was a focus not only on economic elements, but also on government decision-making. In other words, administrative law being a part of this. And we've seen that reflected later as well. Now, there is a logical extension then of the Hurst tradition in law and development. And then what you see is that, what's interesting is, where I picked this up is very early on, long before I had anything to do with Wisconsin, I ran into David Trubek's piece that he published in 1984 on economic, social, and cultural rights in the Third World. And so there was already this interest in going beyond purely the idea of economic development, but what does it mean for rights? How do we get into that part of the world? And here in the mid-1990s, I had the opportunity to co-teach a class with David Trubek on the globalization of law. And so it suddenly moved from this idea of law and development, or even these regional studies, which are so strong in Wisconsin, to this idea of globalization. And that influenced my work to a large degree. I was looking at the time at the movement to transition to democracy in South Africa. And it gave me an understanding of how that was actually embedded in a global context, that it wasn't just a local development or a struggle for freedom in South Africa, but that the developments, the legal developments that follow the process of the transition is in fact embedded in a in a global process. And particularly at that point, the end of the Cold War. Now, what's interesting is in 1989, the World Bank publishes a piece saying very explicitly that for Africa in particular, until governance is fixed, in fact, there's no chance for economic development. And so you get this movement from economic law and the idea that law and development gave us to the idea that, well, actually governance really matters equally, that this is a balance that goes together. And that moved us in the direction that we followed for a long time with global legal studies here, to also think about the role of law, not only on the economic side, but also in terms of governance, in terms of, and that flows, interestingly enough, into the area of human rights. Nobody's mentioned yet that global legal studies was very much part of, and is still part of, creating a campus-wide human rights program. And the idea that it moves, and very interestingly, particularly at this moment, in terms of COVID-19, moves in the direction of interstate relations again. So we've kind of come a full circle from being interested in regions, interested in law and development, in the economy, into governance, to actually focusing now as well, once again, on the transnational and even the international. What is the relationship between states at a moment when you've got a global pandemic, and what that will mean for change? In my own work, it moved from land reform which was, of course, economic as well as governmental, to access to medicines, which at the international level, and I've returned recently to look at community land trusts and land issues, in addition to the constitutional work that I do. I think that's the idea here, is that global legal studies has given us a space in which we can look both at the regional developments, the area studies, which we have been very strong at all along, and to expand that to a broader conception of the relationship that we've just seen in Alex's piece in the flows of law between the North and the South generally. Thank you.
Thank you. Thanks. Okay, so John Ohnesorge is the next speaker.
Great, I'll just get started. So thanks, Abby, Connor, and the other organizers. And of course, thanks to Dave, my friend and mentor, for whipping us into line. So my comments today continue a project that started last year looking at Willard Hurst and the law and development tradition that developed here at the UW. This particular paper, Development is Not a Dinner Party, I first gave at a China law conference at Michigan that asked us to look back at the history of China's law reforms since 1978, when the country began its economic opening. So the paper is an attempt to distill some of Hurst's general ideas about law and development from his writings on the US experience, especially his book, Law and the Conditions of Freedom in the 19th Century United States, and then apply those ideas to the case of China post-1978. So the hope is that that kind of exercise will yield interesting insights or new ways of thinking about aspects of the Chinese situation that are generally accepted as fact. So it's about reinterpreting generally accepted facts. So I should say that this approach, it's based on my crude version of philosophical pragmatism, meaning that I'm not necessarily interested in deciding which theory about law and development is true, or which best explains the country's experience. I'm more of a theoretical pluralist. I'm interested in theories or approaches to the extent to which they add value by yielding interesting insights. So I think applying Hurst's ideas in such a way is helpful in thinking about law and development efforts today. But given his huge influence in this school at the time when the law and development movement was born, it's also interesting to consider, as Heinz was saying, how Hurst's ideas might have influenced the direction of the movement. So who was Hurst? We should probably cover that a little bit. Hurst joined this faculty in 1937, which is kind of amazing. And with a break for World War II service with the government, he was on the faculty until he retired in 1981. He was almost certainly the most important legal historian of the 20th century, at least operating in law schools, and was also probably one of the more important legal scholars in any field. His importance was based on his intellectual influence in the legal process movement, the law and society movement, his kind of single-handed reinvention of legal history, and perhaps in the law and development movement as well. It's fair to say that we're still living in the law school that Hurst built, though it's been decades since he retired. Hurst took an incredibly broad view of law and the legal process, paying attention to the activities of legislatures, courts, executive agencies, and lawyers, as well as contracting behavior, the use of business organizations, et cetera, et cetera. For Hurst, law was what law did. I would be maybe one way to think about it. And he believed that it was possible to look over the vast, complex terrain of law in American history and to discern out of that some dominant patterns or commitments that could describe the work that law was performing in different eras. So this is a methodological approach of his that is, you know, it can take a while to figure out what he's doing when he's talking about law in this way, because it's not a positivist sort of system of rules thing. It's very broad and very abstract. So when he did this with respect to the role of law in the 19th century US, our era of rapid economic growth and development, he identified the primary role of law as being the release of energy, specifically private entrepreneurial energy. So this is a kind of functionalism. So law has this function, but at a very abstract level. So the function was to release, was the release of energy. And it was probably related in some respects to other ideas that were in the air around that time. So maybe including Frederick Jackson Turner's thesis about the role of the frontier in American society. There's a sense of that in when I read Hearst. Keynes's musings about the animal spirits of capitalism, Schumpeter's ideas about creative destruction being an integral part of capitalism, and perhaps Alexander Gerschenkron's ideas about the advantages of economic backwardness for rapid development. The memorable images created by these other scholars, some of which Hearst certainly would have known, share much with Hearst's image of law being used to unleash the energy of private entrepreneurs to drive economic growth as they seek their own fortunes. An important implication of looking at law and development from this kind of Hearstian perspective is that at the most fundamental level, all episodes of rapid market-based economic development are going to be similar. They will all involve legal change that releases the, releases the energy of the people to pursue economic activity. That articulation has a kind of circularity to it, obviously, but because the factors holding back entrepreneurial energy in every society will be different, the measures that are necessary to release that energy will depend on each country's circumstances. So writers on law and development have spilled a lot of ink over one-size-fits-all legal reform programs, but from a Hearstian perspective, it would be almost impossible that cookie-cutter law reform programs would be appropriate because the national factors needing to be addressed would rarely be the same. The truth of this is apparent from looking at two of the most important reforms that China undertook in the late 1970s and early 1980s, which are universally credited with unleashing China's first wave of economic growth. These are the relaxation of China's Soviet-style collective farm system so that farmers could grow some crops that they could sell themselves on private markets outside of the state system, and the equivalent policy in the cities that allowed urban workers to leave their state-assigned work units to strike out on their own with small private business ventures. These reforms did not involve highly detailed legal transplants borrowed from some advanced legal system. They were policy measures articulated in quite general form, designed to loosen the constraints that were holding back the entrepreneurial energies of the Chinese people. Another Hearstian insight that finds support in China's experience is that law can be functional for economic development by not functioning. If it's the law itself holding back the economic energy of the people, then not enforcing that law may prove the path to economic growth, especially if formally removing the law would be too difficult. In China, a great example of this has been the government's policy of selectively not enforcing its notorious household registration or hukou system, another Soviet-era institution that greatly restricted the internal movement of Chinese workers and entrepreneurs. The government greatly relaxed enforcement of the hukou system decades ago, allowing workers to flood into China's booming cities and factory towns, thus driving economic growth, while reforming the actual legal structure of the hukou regime has lagged far behind. One lesson from China's experience is that when non-enforcement is highly functional, as it has been with the hukou thing, functional in an economic sense, a feature, not a bug, it may prove very hard to change. As much as some citizens of Beijing and Shanghai would like the government to start enforcing the hukou system more vigorously to keep out these people that make their lives more difficult, they have not been successful. A third Hearstian aspect of China's law and development story has to do with the negative face of law, something Dave Trubek and Mark Galanter confronted in their seminal Wisconsin Law Review article that Alex mentioned. Hearst's account doesn't dwell on the negative aspects of law in America's economic development, but he doesn't deny them either. Hearst's approach to the legal and economic record was to try to separate description and analysis from approval, facts from values, and he was quite clear about the costs incurred by the animal spirits of American capitalism, especially on the environment in the upper Midwest and in Wisconsin in particular. There's often in law and development efforts an attempt to make necessity out of virtue, to conflate facts and values and to argue that something normatively good, like the rule of law, is necessary for economic development. I suspect Hearst would have had little patience for that kind of effort because his study of our own history often undermines such claims. A related issue is whether law that is good in a technical sense is important for economic development. The great growth in the use of the corporate form by entrepreneurs in our history was not set in motion by discovery of the perfect corporate law. It was set off by states adopting general incorporation statutes that made the benefits of incorporation widely available, rather than being limited to those with political connections in state capitals. In China, legal reforms have often begun as experiments by local governments, which, if they work well to promote growth, were then later turned into general law by higher levels of the government. It seems that good enough law is what matters, not technically advanced law. And that's an important lesson for law and development. Okay, finally, from a Hearstian perspective, it's not at all surprising that China's rapid economic growth has not followed the tenets of sustainable development rhetoric. Hearst presents the release of entrepreneurial energy in our history as setting off a frantic or even violent process, and China's experience supports this. From Hearst's perspective, it would be typical that the economic behavior engaged in during high-speed growth episodes is not sustainable, as it certainly was not in US history or in China since 1978. So in modern terms, you know, he recognized clearly the negative externalities problem, and there were lots of negative externalities that were not being imposed on the entrepreneurs. The interesting question for Hearst was how the American political system finally responded to societal demand for more regulation of the economic system, and eventually started paying attention to the costs of relatively unconstrained economic activity. In Hearst's view, this was partly a result of our political system becoming increasingly democratic at this time, late 19th century. And many of observers of China hoped that China's economic success would have led by now to a more democratic political system. China's political system is moving in the other direction, unfortunately. But nonetheless, the government and the Communist Party have been responding to societal demand for more sustainable growth policies in some areas, I should say, not all, but some. This presents something of a puzzle, but I suppose Hearst would have seen this as a great natural experiment in whether the legal regime of an undemocratic state can respond effectively to the pressures on it resulting from the success of its economic development policies. So I will stop there, and I'm just out of time.
Okay, thank you, John. And so the last presentation is Mitra Sharafi.
Thanks, Dave. Well, I'm going to talk today about how the UW Law School has worked to build a scholarly community in the field of South Asian legal studies. And you've got the map there, so you can see that we're talking about kind of India and surrounding nations. And I'm going to be talking about multiple levels of this kind of community building, both on campus, in academia more broadly, and also on the internet. This talk is not going to be published as a paper in the journal. And so I'm not going to be giving you kind of a slice of my research, but instead I'm going to be focusing on the bigger picture and looking at all of the things that have been and are now going on at UW, because there's a lot. I'll talk about research, I'll talk about scholarly events and groups, and I will finish up by talking about digital initiatives. So a number of scholars at UW Law School have worked on aspects of South Asian legal studies. Mark Seidel has done work on philanthropy in South Asia. Our former colleague Shubha Ghosh has worked on intellectual property in South Asia. And as you heard earlier today, Sumudu Atapattu, although her work is global and international, this theme of climate change and climate change refugees specifically is going to be hugely important for South Asia, and not just the Maldives that is going underwater, but many other countries in South Asia as well. But I'm going to focus right now on the work of two scholars in particular, namely Mark Galanter, who kind of started it all, and then I'll talk a bit about my own work, because I think we're the two who are most focused on South Asia. So Mark Galanter came to the UW Law School in the 1970s, and he had been one of a handful of American legal scholars who spent time in Delhi in India in the 1960s, and they were funded by Fulbright Hayes, Ford Foundation, and other bodies. Pakistan became independent in 1947, and for the first couple of decades after independence, it seems like legal academics in South Asia were really focused on teaching, and there was not kind of a very vibrant research world emerging. But that gets kickstarted in a way when these American scholars spend time in India and then come back to the US and start publishing on it. Mark had also spent time at the University of Chicago, And he was mentored by an anthropologist of South Asia called Bernard Cohen, who ends up being a really important kind of bridge figure, connecting the research going on by social scientists of South Asia with this newer, younger group of law professors. And I think that Bernard Cohen's influence on Mark Galanter was a really important one. So you can see on the slide, I've listed just a small number of some of Mark's work on India. He is probably most famous for the book Competing Equalities, which is a classic on the caste system, inequality, and law in India. But he's also worked on the legal profession. He's worked on Indian courts and the major problem of delay. He has written about aspects of legal pluralism, specifically the panchayat system. Panchayats are traditionally non-state caste or village or community-based bodies of dispute resolution, although the Indian state has kind of experimented in trying to create hybrid forms that are kind of semi-state institutions. He's written about access to justice, and he's also worked on accidents and disasters in India, focusing on the 1984 industrial disaster in Bhopal. And he's connected that a bit to some work on tort and actually kind of the absence of a really robust tort law culture, you could say, in India. I am a legal historian. I'm going to let you see the print a little more clearly here. I'm a legal historian and I focus on colonial India. And so I've worked on, really for the first decade of my career, I worked on law and religion in colonial India. My book that you see here was about a body of personal law. I think the thing that drew me to India in the first place is this notion of personal law in India. There's one body of law for everyone in most areas of law, but when it comes to family law, you get the law of your religion, and it is applied by the state court. So there's this incredible world of multiple religious personal law systems applied by state courts, and my book is about one of those bodies. After that, I did some work on the field, kind of the history of the field of South Asian legal history. And if you want to read more about, for instance, like Mark's early career, I've got some of it in this annual review of law and social science piece, sort of 50-year history of our field of South Asian legal history. And now I'm working on the place where the history of law meets the history of science. I'm working on, go back. I'm working on the history of forensic science, and I'm working on a book project. I've got an article that I just published on abortion in colonial India that is a spin-off project. I've published a piece on blood stain testing and planted animal blood at murder scenes, which will be part of the larger project. My next big project is going to be kind of global in that I'm going to look at the history of legal education and the legal profession across the British Empire and beyond. I'm focusing on non-European students who came to London to the Inns of Court to become barristers or litigators. And I've built up a database right now of about 5,400 plus of these students, demographic information about them between the 1860s and the mid 20th century. So that's a little bit about the kinds of things that I am working on in my research. I also just want to acknowledge that we have some exciting work going on at the level of SJDs, our doctoral candidates here at the law school. Cynthia Farid has just completed a dissertation on the history of Indian courts and constitutionalism, and Mariam Khan is working on constitutionalism in Pakistan. We also had a postdoctoral fellow here at the Institute for Research in the Humanities, which is not in the law school, but at UW, named Elizabeth Loest, who was working with Urdu language sources on Islamic law in colonial India. So we have a lot going on at the research level. We've also built up a number of regular events and groups, networks to foster community and research in this area. In 2014, we started a group called the South Asia Legal Studies Working Group, and we're a group of about 6 to 8 graduate students and faculty members who come together every month and give each other feedback on our drafts. And those drafts are starting to get published as articles now, so it's fun to see the group in that opening footnote. We also host an annual workshop, which is a global event on South Asian legal studies. And that is a small group of scholars who pre-circulate their work. Everyone comes together for one day. And we just had our 14th annual version of that. So that's, I think, helped build kind of the field at a level beyond just UW. And then we have close ties to the Law and Society Association. And I run the South Asia Collaborative Research Network, which is CRN 22, which Mark Galanter and I started in 2005. And that group now has about 87 people, at least on the email list. We circulate several hundred messages every year. We come together at the conference, and UW contributes to the costs of our annual lunch. So UW has close links with that global network as well. Finally, I just want to talk about something that is near and dear to my own heart, and that is kind of the importance of having an online presence. So we have a number of digital initiatives that we've been working on since before COVID, and I'd like to tell you a little bit about some of them. I have a website called the South Asian Legal History Resources website, which is one of the best known in my field. I started it in 2010, so the 10th birthday of the website just happened this past summer. And it's mostly research resources, especially for there's a lot of interdisciplinary scholars in this field, a lot of historians who are not trained as lawyers. And so I've created a lot of resources to help them work through things like case law, for instance. Mark Galanter was very involved in the transnational litigation involved in the Bhopal disaster of 1984. That is generally considered to be the world's worst industrial disaster to date. Between 15 and 25,000 people died when an American-run, American-owned pesticide factory had a spill. Thousands of other people have been blinded since. Mark kept over 3,700 documents from the litigation, and we, including very much the law librarians, created scans of those documents, and they are now available on this Bhopal online digital archive, which is open access. So we hope that people around the world, including in South Asia, will be able to dig into the details on what happened. Sunil Rao at the Law Library has created some great guides to doing research on South Asia. And we subscribe to Manupatra, which is like the Indian Lexis, which very few American law schools have a subscription. So that is great. I'll just end by saying that in this COVID era, I think there's a whole bunch of new and actually rather promising skills that we're developing in events just like this one, online events. We just had our 14th annual workshop and it was virtual. And I think that there's a real potential here for global participation, which especially when you're studying parts of the Global South, I think it's really important to be able to obviously include scholars based in the Global South in your events. But many American conferences are too expensive for scholars based in the Global South to attend. There's a rise in visa denial for many scholars coming from South Asia. There's obvious environmental reasons to do it online as well. So at our event just 2 weeks ago, we had scholars from Canada, the US, and the UK, but also from India and Pakistan attending, and they may not have been able to join us had it been in person. So I'm really hopeful that we're learning a lot as academics, having perhaps truly global online events, and I'm hoping that we can keep some of that even once this crisis is over. I will leave it there. Thanks.
Well, thank you, and thank everybody. And I want to note that we are exactly on time, which is itself awesome. And so I'll turn it over to the students who are going to share the Q&A. And I see there are quite a few questions. And I note there are 126 people, which is pretty impressive.